Application is for quashing of Annexion 9 at page 109.
What is this?
The wife of the petitioner has been substituted. Originally, the husband of the petitioner was a member of a Bihar Administrative Service, and he has retired on 31st of January 1994. Thereafter, a department...
31st of January?
31st of January 1994, as Deputy Secretary from PWD Department, Public Works Department.
He was subjected to inquiry.
He was retired. Subjected to inquiry, departmental. After his retirement, the charge was framed on 27/8/1996. That is more than 2 years after his retirement.
27/8?
27/8/1996.
He retired on 30th?
31st January 1994.
Where is the charge memo?
Charge memo is, my lord, ultimately it was converted into 43B, my lord. Ultimately it was converted into 30...
Where is the charge memo, madam?
Yes, my lord. Charge memo is Annexure 2.
Annexure?
Annexure 2, my lord. Annexure 2.
Page?
Yes, yes. Actually, my lord, the relevant page is page 33. That is Prapatra Ka. Main allegation against...
Allegation is of the year 1993.
That period he was posted as under...
Allegation is relating to 1993.
Yes.
Yes,
1993. So the question of 4 years old allegation is not an hurdle for you. They can initiate inquiry in respect of allegation of 1993. They are not entitled to hold inquiry in respect of allegations of the year 1992, that too prior to September, prior to August. So your contention is not maintainable.
Not maintainable.
Any other contention?
My lord, my submission is that after the inquiry officer exonerated the petitioner from all the charges.
What is the date of inquiring officer's report?
What is the date of?
Inquiring officer's report.
Yes, my lord. Conducting officer, report order of the conduct of his action. Actually, my lord, inadvertently, the inquiry, another document was annexed as an inquiry.
Please answer
report.
to the question.
I have filed a...
Page 70, my lord. Page 70.
No,
not page. That is in a supplementary affidavit I filed. I filed on...
What is the date of charge memo?
Yes.
Yes,
27/8/96.
my lord.
Yes, my lord.
What is the date of inquiring officer's report?
Inquiry officer's report, my lord.
22nd February 2005.
22nd February 2001.
2003.
यही है, हाँ, यही तो है.
My lord will have a look to this, my lord. Page 70 of the main brief, my lord.
Please give me the date, sir.
Yes, my lord. It is 10/1, my lord, 2003.
Speak in my...
10/1/2003.
No.
10/1.
2003.
What is the date of show cause notice issued by the disciplinary authority?
My lord, so cause notice was issued, my lord, on 22nd to 2005.
Second?
By
Second show cause
22nd February 2005.
What is the date of petitioner's explanation?
Explanation, my lords,
Explanation.
is submitted on
At page.
7/12/2005.
7/12/2005.
2005.
What is the punishment date?
5% deduction of from
Punishment.
pension.
Punishment date, my lords, 12/11 to 1/12/2006. 2/12/2006, that is the memo number, my lord. It was signed on 1.
1/12?
No, 2/12/2006.
Where is the 2/12/2006 order?
My lords, Annexure 9, page
Annexure 9.
1. Annexure 9, page 109.
Page?
109.
109.
109. Oh, okay. My lord has got it. My lord.
Where is the consideration of petitioner's explanation, in which paragraph?
My lord, it's written, para 3, my lord will have it. विभागीय कार्रवाई संपन्न होने के पश्चात विभागीय जांच आयुक्त बिहार पटना के स्वयं के जांच प्रतिवेदन प्राप्त हुआ। जांच पदाधिकारी द्वारा श्री प्रसाद के विरुद्ध प्रतिवेदित आरोपों में आरोप प्रकृति आरोग्यशाला राजगीर नालंदा नामक स्वयं के संबंध में पत्र संख्या द्वारा भारत सरकार को अनुशंसा भेजने के पूर्व न तो जांच कराए और न संचिका भेजी और न ही सक्षम पदाधिकारी की अनुमति प्राप्त किए संबंधित आरोप प्रत्यादेश प्रथमा prima facie melody of the found proof. Actually, what has happened?
Explanation has been considered.
Explanation considered, my lord, because that reads, my lord, that says that.
What is the allegation?
Allegation was that, my lords, for allocation of fund to NGOs, my lords, there was, my lords,
Allocation of amount.
yes, my lords, amount, my lord, to the NGOs. I'm sorry. To amount to the NGOs, my lord, he was supposed to make an inquiry whether that NGO is actually functioning or not. My lord, my lord, that the petitioner did not, my lords, made an inquiry. Neither any file was opened for making such inquiry. Straightway, my lords, the recommendation was sent to the government of India, and funds were allocated thereafter. My lord.
Recommendation for release
My lord,
of fund.
releasing of fund, my lord. So that is the, my lord's main charge. And, my lord, ancillary charges, my lord, the preparation and other thing. My lord, that charge is found to be true, my lord.
All
No,
right,
my
now,
lord, that is not correct, my lord. I have annexed the inquiry report and the inquiry.
Any legal issue, madam?
My lord, conducting officer has come to the conclusion no fund has been disbursed on the basis.
All right, any legal issue?
Legal issue is that under rule 43B, my lord.
Who is the author of Annexure 9?
Annexure 9 was written, my lord,
Issued by whom?
Annexure
my lord,
9.
it is issued by additional under secretary, my lord. And, my lord, decision is taken by the government, my lord, government in the file, my lord.
Yes, madam. Any
My
legal
lord,
issues?
my lord, my submission, I am on 2 points, my lord. And rule 43B speaks that the can be constituted only on 2 grounds. That is grave misconduct and pecuniary loss. And the conducting officer has exonerated the petition from all the charges, including charge number 7. That is the allegation that he has, due to his recommendation, 2 crores rupees were disbursed, and that has been misused. And that charge could not be proved, and he has come to the conclusion, accepting the sending recommendation letter, no, the department could not produce any letter, any enclosure. Therefore, no, he has no sanction, no money has been disbursed as a result of his recommendation. Therefore, my submission is that there is no pecuniary loss to the government, and my definite submission is that there is no prescribed procedure for sending recommendation, and the petitioner made several correspondence to the higher authorities.
No, in which paragraph the disciplinary authority has held that you have caused loss to the state exchequer on account of non-existence of NGO and other things?
Yes. That is in conduct. That is in inquiry report, my lord.
No, not inquiry report.
Yes, yes.
Inquiry report is in your favor. Correct? Inquiry report is in your favor.
Yes, he has been.
That is the reason now we have to go to the next stage. Disciplinary authority has disagreed with the inquiring officer's report and found that NGO was not existing or NGO certain deficiency. Where is that?
Milord say it is not correct, Milord. There were 10 charges,
No.
out of which, Milord, 1 charges was proved that which
That
were,
is the
Milord,
sending
How many
of
charge?
recommendation.
Milord's charge number 6 was found to be proved.
No, total how many charges?
10 charges, Milord.
10
8.
charges. 10 charges.
Yeah, how many charges were proved?
One
Milord,
charge.
only 1 charge
Only
out
one
of
charge.
that.
One is proved.
Yes.
One is proved.
And that is
what
what
is the what is that proved charge?
proved charge, Milord, that not
That he has sent recommendation.
Allow him to
No.
submit.
no parallel.
All right.
Milord, that main charge is, Milord, without making any inquiry.
Correct, sir. Thereby any loss has caused to the state exchequer.
Milord, the funds were released, Milord, to that.
Correct.
No.
How much?
Milord, 2 crore, Milord, that was allocated for that particular financial year, Milord.
But
What action you have taken against that NGO?
NGOs, Milord, that is not on record because, Milord, Milord, we have off the record, we can say, Milord, because there, in those days, Milord, what had happened, that, Milord, there were a fire, Milord, registered against some of the NGOs, Milord, which were actually not functioning. But that is not on record. I cannot say with full conviction. But that
What is the punishment now?
but
punishment 5% reduction in pension, Milord.
may I place my
Sorry,
lord,
madam, we will not interfere. Yes, take down.
My lord-
Instant petitioner
My
has
lord, one thing, I may be allowed to read from the inquiry report that no fund was disbursed on the basis of the.
Sorry, madam, we will not interfere.
My lord, may kindly allow me to place that portion of the inquiry report.
Madam, this court cannot reappreciate evidence as held by the Supreme Court recently in the case of some Dalbir Singh or something. So also our earlier case 1995 BC Chaturvedi. Yes, take down. In the instant petition, petitioner has prayed for the following relief. So petitioner was subjected to, petitioner while working as a deputy secretary attained age of superannuation and retired from service on 31st January 1994. Thereafter, on certain allegations, he was subjected to disciplinary proceedings on 27/8/1996 while framing 8 charges. The inquiring officer submitted his report holding that 1 charge was proved. On receipt of inquiring officer's report dated 10/1/2003, the disciplinary authority issued a show cause notice on 22/2/2005 seeking petitioner's explanation on the inquiring officer's report. Petitioner submitted explanation on 7/12/2005. Thereafter, the disciplinary authority proceeded to impose a penalty of withholding of 5% from the pension on 2/12/2006. Thus, the petitioner has presented this petition to Land Council for the petitioner submitted that having regard to the charge, having regard to the proved charge, there is no grave misconduct. Therefore, imposition of penalty of 5%, withholding of 5% pension with reference to Rule 43(2)(b) of so and so rules is arbitrary and illegal. Per contra, and counsel for the respondent resisted the aforesaid contention and submitted that charge proved is relating to release of fund to NGO. The petitioner as a recommending authority / officer without examining the various issues whether the concerned NGO fulfills the requisite criteria for the purpose of claiming certain monetary fund from the state or not. Such a charge was proved. Based on the recommendation of the petitioner, certain amounts have been released in favor of NGO. Such a allegation, such a proved misconduct amounts to grave misconduct. Merely non-mentioning of grave misconduct in the impugned order, the petitioner is not entitled to claim that the alleged proved charge is not a grave misconduct. Hurdle and counsel for the respective parties. Undisputed facts are that the petitioner was subjected to disciplinary proceedings on 8 charges. 1 charge was proved. Though inquiry has been held after retirement of the petitioner, however, it is in accordance with the relevant rules. Question for consideration is whether proved charge is a grave misconduct or not. Undisputedly, the petitioner as an officer of the department had recommended for release of certain funds to the NGO, and it was not after holding an inspection and NGO fulfilling the relevant criteria for the purpose of claiming fund from the state. Prima facie, there is a loss to the state exchequer in releasing fund to the state, to the NGO on the recommendation of the petitioner. Such a recommendation without inspection and without material information that NGO was eligible to claim certain monetary benefit from the state or a scheme amounts to grave misconduct. That apart, recently Apex Court in the case of so and so held that courts, tribunals and courts should not reappreciate evidence. In the light of the Apex Court decision in the case of Dalbir Singh so and so, the petitioner has not made out a case so as to interfere with the impugned order. Accordingly, petition stand dismissed.